This is George Brunt and Jessica Cahoon, and we are with Business Legal Management and the Business Law Group. And we do these monthly seminars to talk about ways that CEOs can better protect their brand and make legal an asset. Jessica, shall we go through the slides today?
All right, great. Thanks, George. So today we're going to be talking about the top 3 things that general counsels want CEOs to know about litigation. And when we talk about litigation, that means basically when you are either ramping up to sue another individual or entity, or when someone has engaged your company in a lawsuit. So the first thing that we feel is important is that you as a company involve legal and compliance on the front end of your business decisions. So sometimes this starts right from the very beginning with your corporate structure. Most companies are already set up, but even as you continue through doing business, this would mean having attorneys review your shareholder agreements or operating agreements and things like that before you start making decisions that might affect ownership interests in the company or things of that nature. And then also, obviously, I think most people have their attorneys review their contracts or when they're terminating a contract to make sure that that is done appropriately. With real estate, when you are either purchasing a new real estate holding or entering into a lease, a lot of times it's a good idea to have your general counsel start reviewing those agreements and what that deal might look like from the beginning, rather than after you've already negotiated all the key terms of your agreement. Next, putting out a new product or a new service. If you involve your legal department or your compliance department, they can really try and help you make those things become an asset that's worth something to your company. Whether it is creating and protecting your intellectual property rights, such as your trademarks, or making sure that you have really good warranties, those kinds of things. We don't want to have general counsel get in the way of you putting out something new and exciting, but just to make sure that you're doing it to where you have something that's worth value to you later. And then also, of course, to make sure that you're not infringing on anyone else's intellectual property rights when you're putting out these new products. The next topic that you might think about involving your legal or compliance department on the front end of decisions is when you're hiring or firing employees. That's not to say that you need to have your attorney look at every single employee that you ever hire or fire, but when you're working with maybe a member who's going to be part of your executive team or that's going to have an actual employment agreement, it's probably a good idea to have your counsel look at that agreement before you offer it to the employee. Additionally, when you're letting an employee go, you want to make sure that you're following through on those agreements and that any severance package that you're offering complies with the law. Now, your general counsel is usually pretty well versed in a lot of areas in the law, but sometimes you might run into a problem that's outside of their expertise, and you shouldn't be afraid to hire an outside firm to assist you in getting advice on whatever that particular area is and making sure that they work well with your general counsel. And then the bottom bullet point is, if you wait until you're getting sued, it's probably going to cost you a lot more time and money. Sometimes I think that companies are afraid to talk to their attorneys because they're afraid of getting in trouble or that they've done something wrong, and maybe it's a little bit embarrassing to them. But you just have to realize that if it's something that could put you into hot water in a legal sense, and you're sued for it later, whatever that embarrassing fact is will probably come out at a later time. So it's just better if you involve your attorneys from the get-go on that, so that way they can help mitigate any problems that might arise. Um,
So Jessica, litigation can be very expensive, and even worse than that, it can deflect you right from
right.
roles in your business responsibility. So just a couple of anecdotal stories on this. It's interesting. I know, I remember one company who had in their corporate documents that all of the partners had to approve a raise in pay for the CEO, and therefore one partner could say, no, I'm not going to do it. And it can destroy a company quicker than anything. So it's really important to look at those initial corporate documents and to keep them updated, right? To keep them updated from time to time. If you want to, you can't bring in an investor with an agreement that gives someone veto power over salaries. So you have to really think these things through, and you have to keep them updated and modified. I would say a corporate operating agreement should be looked at every year. The same with most of the policies, especially employee policies. You mentioned hiring and firing employees. I remember one company who let a person go. She was 60 years old, and they didn't follow the right procedure, and they ended up getting litigation, paying $400,000. So these things can be very expensive, and you have the attorney on the front end. And I think that's the point you're making here is,
Right.
you're on the front end, you can avoid a lot of pain.
Absolutely. And I think it's kind of like if you don't give your attorney sufficient information, it's like hiring a chauffeur for your car and not informing them that the brakes don't work. That, you know, you're just going to crash into a lot of problems that could be avoided otherwise. And so I think that when you give your attorney the opportunity to help you from the beginning and to give them the relevant information, that you're just going to do yourself a favor a lot later. Which kind of brings us to the next point that you were talking about, George, that litigation takes time and it's very unpredictable. And so I think a lot of times when you get started into a lawsuit, it's really overwhelming and you feel like, oh my word, my attorney just doesn't understand that I don't have time for this. And I think that we do understand that as attorneys, but sometimes our clients don't understand what is involved in getting a lawsuit from start to finish and how long it takes. So a quick lawsuit that actually settles out of court takes, you know, around 6 months, just due to the time of filing the documents, entering into settlement negotiations, and drafting up those final agreements. Something that goes to trial that's relatively more simple is usually 12 to 18 months, and it can be 5 to 10 years as well, depending on the facts of the case and what jurisdiction you're in and how busy the court is. And usually if you actually go to trial, that involves at least 1 day to 3 weeks that you are distracted from running your business and that your employees are distracted from running your business. So I wanted to talk a little bit about how that works and why it's so expensive. So you have to understand that adequate preparation for a lawsuit, even from the beginning, just takes a lot of time. There's an investigation phase that happens. That through part of that, they start drafting what's called a complaint that starts off the initial lawsuit, or an answer and a counterclaim if you've been sued. And doing this investigation phase and drafting these initial documents takes several weeks to several months just to get the ball rolling. And you can expect to pay anywhere between $10,000 and $50,000 just for phase 1 of a lawsuit. After that gets kicked off and you actually have a judge assigned to your case, you enter into what's called the discovery phase. And discovery is kind of what it sounds like. You're discovering what information both sides to the case have. And that's kind of a painful process for companies to go through. Because as part of that, they can request documentation from your company. They can request that individuals answer requests for admissions or produce answers to more broad questions. And it takes a lot of time to prepare those answers, to find all of those things, and discovery can be very expensive, upwards of $35,000, $40,000 to do all of that.
And that could just be an attorney's fees. You might also have to pay experts to go in and take the information off of your computers.
Right.
for several years in the past. And so it can become very expensive from that point of view too, just from a technician point of view.
Absolutely. And then you get into, everybody I think has heard of depositions, which is basically where you interview an individual, both sides are there and are allowed to ask questions. It's run somewhat like how you would expect it to go in court, but it's outside of court before the trial ever happens. And if you are subject to a deposition, it takes a day or two of just time in an office, being answered question after question after question. And so there's a lot of preparation that goes into that for whichever of your employees are being deposed. And for each deposition, I find that it normally costs somewhere between $10,000 to $15,000 per individual. And so if you have a dozen employees that need to be deposed, that cost escalates very, very quickly. And it takes time, again, away from your business, and it takes your employees' focus off of things that are more important. And then finally, after you do all of that work, months or years of work, you finally get to your final trial prep and your actual trial. And that includes analyzing all of the documents that have been filed, everything that's been sent to both sides, all of your witness preparation, oral arguments, those kinds of things. And that cost is really hard to predict because it really depends on how long the trial is. Now, you notice something that we haven't talked about yet, and where most cases actually wind up going, is settling somewhere in between all of these phases. And the court system is really designed to force parties into settlement because of how long and expensive this is. And so something that we like to talk to CEOs about is the importance to pick the important fights. And this would be our third point. So there's just a couple of questions here listed for you to think about. That first of all, should you engage in litigation? And that's really a case-by-case thing. Sometimes it's a one-time deal that's happened, that maybe it's not worth the money at that point in time. Or maybe it's something that you feel like is going to come up multiple times, not just with the company that or individual that you're having an issue with right now, but that you can see it being a problem many times down the road. At that point, it's probably worth it to engage in litigation. You should think about, what do you stand to gain versus what do you stand to lose? And then are there other options out there that could accomplish what your end goal is? And if there's other options, then maybe those are better options than engaging in litigation. If you're already in litigation, you should think about, what is it going to take for us to take this to go to trial? And what does it take to settle? And sometimes it's wrong to be right, but sometimes you really are right and that you could be successful at trial, but it's going to cost you maybe 3 times more than what you would ever recover in a court setting. So when we are discussing litigation with clients, something that I like to ask them about is, why are we fighting over this? And if you don't know the answer, then you probably should relook at whether or not this is an important fight that you want to spend the money on. Something else is, a lot of times I hear from clients that say, well, my opponent's going to have to pay my attorney's fees if I prevail. And the answer is, well, maybe not. Judges sometimes are reluctant to award attorney's fees unless your opponent has taken an incredibly frivolous position. And you should understand that most cases settle. And in that case, when you settle, both sides are going to pay your attorney's fees. So if you're pursuing a lawsuit because you think you're going to win and your attorney's fees will be picked up by the other side, it's probably not the best reason to file a lawsuit. The last bullet point on this is to not let your emotion run your litigation. Don't take a lawsuit personally. A lot of times the dollar figure that you see that's first asked for is something that's being, that's their best case scenario that they're asking for. And sometimes that's actually driven by statute or by rules of civil procedure and isn't really reflective of what their actual damages are. So don't be insulted by the dollar amount that you see that's in their complaint. And just because you're being sued, it doesn't mean that you have done something wrong or that you're a bad company or a bad individual. That it's really important not to let that emotion cloud your judgment. And I think that's a hard thing to do. I'm sure, George, that you have many examples in your career of when people have allowed emotion to run their litigation.
Yeah, definitely. And it's usually costly. You really need to analyze the facts. And so these have been 3 things that CEOs should know about litigation. And we really like to counsel our CEOs to not let emotion run their litigation, but to go through the factors that Jessica's outlined here and to really make solid decisions when it comes to litigation. Litigation can be used as a very effective tool, and it can also be a very distracting stab in the arm.
Right.
And something that really can take you away from what your goals are and what your business is. So it can be used either way. It can be used positively and it can have a negative effect.
Right. And when you decide this is the fight that's important, then, you know, that's your battle. That's the one that you pick and that's the one that you go for. Even when it's important at the beginning, you know, it's important throughout the process to make sure that this is still the important fight for your business right now, because maybe it's been 2 or 3 years and you've made your point. And so maybe at that point it's time to settle, or maybe not. But it's something that you should really, really consider. So,
and you should get professionals to manage your litigation. And that's often what role that Jessica and Business Law Group performs, is working with other trial firms with specialties but managing that litigation to try and keep the costs down and the objectives clear.
Right. So if you have any questions about it, feel free to contact our firm at Business Law Group. Our address and phone number is up there. And we're happy to discuss any of these issues with your companies, as well as how you can make legal become an asset for you, whether it's through regulation or protecting your intellectual property rights and things like that. But we really enjoy working with CEOs in a different way than what they're used to working with lawyers. And if you have any questions, please feel free to contact us.
Thank you, Jessica.
You're welcome.